Hi, I'm Matt Staver, founder and chairman of Liberty Counsel and the dean of Liberty University School of Law. Liberty Counsel is a national religious liberty organization. We have offices in Florida, Virginia, Washington, D.C., Texas, and affiliate or volunteer attorneys in all 50 states. As a former pastor and now a constitutional attorney and dean of Liberty University School of Law, I have a significant interest in what pastors and churches can do with respect to political activity. Oftentimes, pastors or churches receive threatening letters from groups like Americans United for Separation of Church and State, or maybe even the ACLU, saying that if you engage in any political campaigning on behalf of a candidate or talk about the candidate's viewpoints, or if you support legislation such as a state or federal marriage amendment or other legislation, that somehow you're going to jeopardize your tax-exempt status. And unfortunately, many pastors feel intimidated and as a result do not even talk about biblical or moral issues with respect to candidates. And yet the scripture says that when the righteous rule, the people rejoice. And conversely, when unrighteous people are in office, the people moan. That's why it's so important for pastors to become the moral conscience of the community, to lose the vocal laryngitis and to remove the muzzle and instead exchange it for a megaphone when it comes to addressing these important moral issues of our day. The sanctity of human life hangs in the balance with many of these individuals that we elect to office. We must not be silent with respect to these candidates' viewpoints on these important issues of the day. Not only must we talk about these moral issues, but we must also encourage people to engage in the political process. We can complain and moan and groan, but if we don't go to the ballot box and vote our biblical and Christian values, then we have no one else to blame but ourselves. Liberty Counsel has been involved in many situations around the country, educating and providing free legal defense and information to pastors and churches with respect to political activity. Let's begin with this simple one proposition that I think is important for you to understand: the difference between churches as nonprofit tax-exempt organizations versus any other organization that's tax-exempt and nonprofit. Take, for example, Liberty Counsel. Liberty Counsel is a national tax-exempt nonprofit organization, meaning that it does not pay federal taxes and contributions to Liberty Counsel are tax deductible. In order to achieve that status, Liberty Counsel, like every other nonprofit organization except for churches, must apply to the Internal Revenue Service for that status. You fill out a lengthy form and wait maybe 12 to 18 months for the IRS to respond. When the IRS finally does, if you're granted that status, you'll get a letter in your mailbox that you can file that says that you have now been recognized under the Internal Revenue Code as a tax-exempt nonprofit organization. Therefore, you no longer have to pay taxes on the income or contributions you receive, and contributions are tax deductible. But uniquely, unlike any other church or any other organization in the country, churches do not need the letter. Churches are automatically tax exempt from the moment of conception, if you will. From the moment of creation, churches are tax exempt without the necessity of asking the Internal Revenue Service for that tax exempt status. That's a big difference, which we'll talk about in a few moments. From 1954 to the present, when we talk about political campaigning, that is, opposing or supporting candidates for elective office, from 1954 to the present, when that was added to the code, not one church has ever lost its tax-exempt status. In fact, from the foundation of this country until 1954, pastors and churches had no restrictions on supporting or opposing candidates for elective office. You could do that, and that was part of our constitutional system. But it was in 1954, when Senator Lyndon Baines Johnson was elected as a senator of the United States, that he proposed an amendment to the IRS code because a nonprofit organization, not a church, opposed his candidacy. To get back at this organization once he was elected to office, he then proposed an amendment to the IRS code, and that was adopted without any debate or any recognition of its impact. What this provision now says is that churches or nonprofit organizations, any organization that is tax exempt or nonprofit, tax deductible, those organizations cannot endorse or oppose a candidate for elective office. So, for example, if Liberty Counsel were to endorse officially a candidate for office, it could lose or jeopardize its tax exempt status. The same for churches. But the important thing to know is this. There is a significant difference between churches having to obtain approval for tax-exempt status, which they do not, and nonprofit organizations which have to obtain approval from the IRS. There's only one case that I think you need to know about. It's a case involving a church in New York. This church, or the church at Pierce Creek as it's known, was the only case and the most significant one that ever got in trouble with the IRS for endorsing, or in this case, opposing then Governor Bill Clinton for office. But even that church did not lose its tax-exempt status for what it did. Here's what the church in New York did. In 1992, this church took out full-page ads in the Washington Times and the USA Today newspaper. They opposed, officially as the church, Governor Bill Clinton for office of the United States of America. He was then elected to office, and a few weeks later, the Internal Revenue Service contacted this church at Pierce Creek. This church decided that it wanted to take the IRS on directly, and so they ultimately filed a lawsuit. In this case, the church, although it didn't have to, it actually voluntarily chose to obtain the letter like another nonprofit organization would do. They wanted to have this letter returned because the IRS, when they could not negotiate a resolution with this church, took the letter from the church. The church then filed a lawsuit against the IRS wanting to get the letter back. This is what happened when it went to the Court of Appeals on this case. The Court of Appeals said that the IRS had the right to be able to take the letter from the church, but significantly, the IRS in this case said and admitted, particularly in front of the court, that not one of the contributions ever given to this church would ever be jeopardized by this particular activity. Not one individual lost their tax-exempt contribution. The church didn't lose its tax-exempt status. And the court specifically said this, that obtaining the letter, or actually even revoking the letter, was more symbolic than substantive. In other words, when the IRS took the letter away from the church, it had no real teeth. Why? The difference would be this. If the letter was taken away from Liberty Counsel or any other nonprofit organization that's not a church, what would you have to do to get your tax-exempt status back? You'd have to apply to the IRS again, wait 12 to 18 months, and hope the IRS would grant that request in order to retain your status. But for a church, all you have to do is every new day is a brand new day. Since you don't need the letter in the first place, it doesn't matter if the IRS takes it. Sunday is different than Monday. If on Sunday the church endorsed a political candidate for office, then on Monday, when the church did not endorse it, the tax-exempt status comes right back into existence. We're going to continue to talk about this because this is a very critical issue that you must know, and it distinguishes significantly churches from other nonprofit organizations. Churches don't need a tax-exempt status letter. So in this particular case with the church at Pierce Creek, although the IRS took its letter, it did not take its tax-exempt status. And in fact, that church, even though it did this process of endorsing, or in that case, opposing a candidate by putting a bullseye, so to speak, on its chest, taking out full-page ads, mentioning the church in the byline, asking for contributions for additional ads, something that most churches would not do to that extent. Even that particular church, taking out this kind of ad in 2 nationally distributed newspapers, never lost its tax-exempt status. Yes, it lost its letter, but it never lost its status. It remained tax-exempt before this situation, and it's continued its tax-exempt status even after the situation, because for churches, churches don't need the letter. In fact, when Dr. Jerry Falwell founded Thomas Road Baptist Church, all the way from that time till the present, over 50 years, that church has never obtained a tax-exempt status letter. And in fact, if you do a survey, about half of the churches in America have tax-exempt status letters and half do not. But all of them, if they're operating as a church, are tax-exempt. That wouldn't be true for nonprofit organizations that want tax exemption. If you want tax exemption as a nonprofit organization, you must have the letter from the IRS. And if you lose it, then you have to get it back. But for a church, every day is a brand new day. From the moment of conception, the church has its tax-exempt status without even asking or requesting such status from the Internal Revenue Service. So consequently, in this case, the church never lost its tax-exempt status. Let me ask you this. From 1954 to the present, if not one church has ever lost its tax-exempt status, despite the protest of the so-called Reverend Barry Lynn of Americans United for Separation of Church and State or other organizations like the ACLU, if they have no success rate in revoking a church's tax-exempt status, even when a church takes out full-page ads opposing a candidate for presidential office, then why are we intimidated? Why are we silent? If the Americans United for Separation of Church and State has a zero success record in revoking these tax-exempt statuses of churches, then why are we silent? Why are we intimidated? That's, I think, the important thing for pastors and churches to know. Now, aside from taking out full-page ads in newspapers, which this church did in Pierce Creek, aside from the fact that every new day is a brand new day, so that if you endorsed a candidate and you accidentally stepped over the line, for example, on Sunday or Monday, well, then Monday or Tuesday is a brand new day. In this case, the church at Pierce Creek, since the election had already been over, could have agreed that they're not going to be continuing to endorse or oppose candidates for political office. Thus, therefore, they would have continued to even have their tax-exempt status letter. Every new day is a brand new day for a church. It's like being born again, if you will, every new day. Whatever happens that day is in and of itself relegated to that day alone and will not ultimately revoke your tax-exempt status irrespective of what you do. Now, we're not talking about intentionally or illegally violating the Internal Revenue Code. We're talking about a church in this case who did that knowingly. That's not what your church may want to do, and that's not necessarily what we're recommending. What we are saying is that if that church never lost its tax-exempt status, then you, when you get into the pulpit and talk about marriage being the union of one man and one woman, and then you give out voter guides or you talk about the different candidates' viewpoints on these particular issues, that is not going to jeopardize your tax-exempt status. Here's what churches can clearly do with respect to opposing or supporting candidates for elective office. Churches, for example, can give out objective voter guides. These voter guides can list the various viewpoints of either the incumbents or the new candidates for this particular office, whether it's federal, state, or local. These voter guides need to be on a broad range of issues. You could give information about how they respond or how they voted on issues such as abortion or marriage or the war or the federal budget or a number of other things, education and so forth. Give several ideas or several ranges of viewpoints or issues that these candidates have taken positions on. Then in the voter guide, these voter guides should be neutral. You shouldn't have pluses or minuses by the name indicating that you support one and oppose the other. But these particular voter guides can just simply be objective information pieces that talk about the candidate's viewpoints. The pastor, as well as giving out these voter guides, can talk about the biblical and moral issues of the day that are relevant to these particular campaigns. Obviously, a big issue that we're going to be facing in the upcoming presidential election is the particular candidate's views on abortion, homosexuality, marriage between the union of one man and one woman. What kind of judges would this presidential candidate or other gubernatorial candidates appoint to their offices? All of those issues are very important and should be preached and talked about within the church. Then the people in the church should be able to know what these candidates' viewpoints are on these particular important moral and religious issues.